Good morning, everybody. Welcome to the third annual Scary Stories from the HR Department. We appreciate you guys coming every year. HR is often filled with nightmares. This year is especially true. It's really hit a little too close to home. We never thought we'd see a year like this. And I guess there's no better time than to use Halloween as a backdrop for talking about scary stories and the outbreak and all the nightmares that come along with it. So today, Claire Vujanovic and I will be presenting this seminar, and we hope that it is an update. We don't want to repeat information or go back over a lot of what we, have both spoke about in months past or the things that you're necessarily living with. We're going to try to bring to you some real life examples, figuring out what we're going to do as the paid leave provisions expire, as cases continue to rise. Both here and Fayette County are governor's red zones, and what that means and how we're going to continue to navigate our employees and to keep our business open are things that we definitely need to continue to talk about and address. We are going to do things a little bit differently this time. We have added an interactive component. There'll be a few polls that you'll have 20 seconds to answer a poll question. And hopefully that will keep people engaged, and we're going to try that as a new feature. We are also going to get you out by lunch so that you don't sit here completely starving, and we want to respect your time as well. The other thing we're going to talk about today, because it is timely, we've got an election, I think, in 5 days. And a lot of businesses have been experiencing strife amongst their employees, fights, aggressive behavior, just some language that is inappropriate in the workplace and causing disruption. So at the end of this seminar, we're going to talk about how to handle that. Claire's going to address the complicated issues and what you can do today to prepare for November 3rd, 4th, 5th, and hopefully not too many days after that, regardless of your party affiliation or who you're voting for. So again, I want to welcome everyone, and let's get started. But I gotta figure out how to advance the slides, Brian. I pressed oh wait, there we go. I pressed the arrow, but is the arrow the one that works? Hold on, spacebar. Okay, sorry guys. All right, as we all can attest to, 2020 has been the scariest year ever for a lot of reasons. Not only did we have a pandemic, but we had a new law come into place that all of us were asked to interpret within 24 hours of its enactment. You had to enact it and enforce it within your businesses. And we've had to come up with a new normal, if that really is even a thing, that this is normal. You guys have been on the front lines. I know we talk about frontline workers being our dedicated healthcare workers and first responders, but business owners and HR departments that are trying to keep businesses up and running and balance the needs of the employees are also on the front lines because of the issues that you have faced. We deal with employee safety. We're dealing with time off and absences. We're dealing with fears, people wondering if they're going to get it, how is my employer going to protect me? And at the same time, under all of this, we're trying to keep our business afloat. All of these things have created a lot of issues and a lot of things to balance. And on your plates, it's been exponentially hard. So we're going to start with issues that are related with the pandemic, like I said, and then we're going to go into some alternative work arrangements, some of the issues that you have there and how we can implement better strategies. And finally, and probably the most frightening of all, like I said, we're going to discuss the political unrest in the workplace. All right. As we all know, back in May of this year, Governor Beshear issued Healthy at Work guidelines. And those included making sure we have on-site or employee self-health screens. We all know what these are, and so we're not going to go through them necessarily, but I do know that they've caused some issues in your workplace. And they're going to continue to cause issues. We are going to have to decide what we're going to do after January 1st when our leave runs out, when our Leave Act expires. And so these are the types of things that we want to talk about. And over the course of this, if you have a question, I believe we have a chat feature. Brian, do we have a chat feature? We have a chat feature. You can throw questions in there. We also have a Q&A as well, and we'll try to answer those towards the end. So let's go ahead and move on to some of the issues with our healthy at work guidelines. Now, part of the self-screen allows employees to identify their symptoms. So let's talk about what issues arise when employees are identifying their symptoms. What are you doing with them? What should you be doing with the identification of symptoms? So our first scary story is where you have mandatory temperature checks, but employees are pushing back, whether it's on the symptoms or on the temperature itself, claiming that it's a violation of their rights under the ADA. We've probably dealt with this. I think we're going to continue to deal with this. And so what are we doing? So our first poll question is going to be an easy one. It is hopefully going to elicit a quick response. Like I said, we'll have 20 seconds for you to answer. And the question is, can employees refuse requests from employers to take their temperatures or submit to questioning about their COVID-19 result? Poll will be open for 20 seconds. Will you? All right, so here's the results of our poll. Thank you for participating. We had an overwhelming majority of people say, or not over, we had about half say no, half say yes, and a small percentage say maybe. The answer is yes. You can require employees to submit to a COVID-specific screen. The ADA and the EEOC both allow this. And one of the reasons is that the EEOC has gone to great lengths to classify this as a very unusual and limited situation. Employers might be worried, or employees more especially might be worried that, well, if they're going to start asking me this medical information, what prevents them from taking other medical information? The answer to that is this is a very specific and carved out exception. You can ask for and require these temperature checks and screens. And in fact, our governor requires it as of May 11th of this year. Now, when you're doing this, you should be using this information solely to protect your employees. We're not going to ask questions that go beyond the COVID-19 issues. So if someone has asthma or has some other condition, we can't really start asking them about another condition. It has to be solely related to COVID-19. You also can't turn a blind eye. We get these forms in every day, and I am the lucky person in our firm that receives the forms and has to work with my team to act on them. If we have one symptom, two symptoms, three symptoms, what do we do? You can't just get the information and people are checking yes and you not follow up on it. So let's talk about what we're going to do to follow up on it. So you should either have in place right now an electronic form or a paper form, whether you do on-site or self-screens, and those need to be done every single day for the foreseeable future. Again, that's to protect our employees from spreading the disease. So what do we do, right? We have this whole list of symptoms, and if I'm prone to allergies, I might have a scratchy throat that I know is an allergy-related symptom. But I check, yes, I've got a scratchy throat. What if someone checks, yes, they have a fever and no other symptoms? What if someone checks free? What's the plan? You, as whoever your healthy at work officer is, whoever is the one person or the team of people that are dealing with these forms, need to have a system in place. So fever alone should disqualify someone from coming into work. If someone has a fever, they should stay out until they're 24 hours fever-free without any other symptoms, because that is one of the most common and most, significant COVID-related symptoms. Cough, sore throat, muscle aches, all of those, standing alone may not be enough to say you should stay away from work, but you need to have a plan. You need to know your workplace. Is your workplace one where people it's hard to social distance, or is it one where everybody's in offices? Is it when you get the information, you can pick up the phone and say, I see you check yes to a cough. Is that related to a known condition? They can, without disclosing the known condition, can say yes or no. And if it's no, then we need to decide, and everybody needs to have a plan. What are we doing? you can say, look, I need you to self-isolate, I need you to stay away, I need you to stay in your office, I need you to, whatever the case is, until the symptoms subside. You can also be super strict and say, even one symptom, I need you to either not to come to work or go home. You have to have a plan for what you're going to do. So those types of things need to be in place. And those are the types of things that we should have been doing and should continue to do. And if you don't, let's go ahead and put that in place now. So more often than not, when we have symptoms or if we have someone who is a suspected or known positive, the very next question is going to be, who was in close contact with you? And my goodness, I can't tell you the number of different scenarios that I've received for defining close contact. I was at dinner with someone who tested positive the day after we had dinner, or I was in a home with someone for a few hours and one of the people there tested positive, or I was at dinner with someone who told me that the next day he had been in close contact with someone before we met who was positive. The scenarios are endless, and they operate much like a high school algebra word problem to me. So what do we need to know? There was a definition up until about a week or two ago that close contact meant anyone who was within 6 feet for 15 or more consecutive minutes was in close contact and should isolate if there was a known positive case, which would mean that those employees of yours who fell within that definition should quarantine for 14 days. The new definition came out of a case, I think in New Jersey, where a jailer who was wearing a mask was within 6 feet of a positive prisoner over the course of a shift, and was never in contact with that prisoner for more than 15 minutes at a time, but over the course of the shift, that time added up to 15 minutes. So now the CDC has a new definition, which is going to wreak havoc on us over the next few months, that close contact now means 6 feet for 15 or more minutes over a 24-hour period. So if I'm in Claire's office for 2 minutes in the morning and 4 minutes in the afternoon and 6 minutes towards the end of the day, and then we'll say 8 minutes towards the end of the day, my math was incorrect there, I now have been in close contact with her if she tested positive or if I did. So that means you're going to have more people that you're going to have to determine in your office who were in close contact, and you might have more absences because of it. So this is also true whether or not you are masked. The existence of a mask doesn't change this definition. So it's important to know, and it's important to understand how it's going to affect your workplace. All right, so what do we do if we have a COVID-19 positive test by one of your employees? We need to notify the health department, and we need to gather all the information that's necessary to do that contact tracing, whether you're doing it yourself or whether it's required by the health department. I can tell you that the health department might even ask for information that you would need to look at documentation for, which is why in previous seminars we talked about what documentation is necessary, why we're keeping it, so that we can quickly and easily get this information to the health department and also use it for your own contact tracing purposes. When you are trying to figure out the close contacts, you don't go and ask the employees, hey, has anyone come in contact with Claire over the past 48 hours? Because she's positive. Because while that is not a HIPAA violation, because employers are not bound by HIPAA, it does have privacy concerns. And while what you may think of that privacy concern is really irrelevant. So what we need to do is ask Claire, who were you in close contact with? And here's the definition. And then you get those names and you say to the employee, you've been identified as someone who was in close contact with a positive test. We need for you to quarantine, or you might be contacted by the health department. We have also gotten questions from clients about how the health department is handling the particular case. And we have had some degrees of varying success in speaking with the health department and facilitating the conversation in case there are some issues with who should be properly contact traced, or in one instance, whether your business should be shut down. So you can reach out to us or any other counsel for that particular reason. All right, so what about what should you do outside of the health department issues? I want to tell you that the CDC has an FAQ for businesses that is helpful. If you go on the CDC's website, it is all over the place what the information is vast, and sometimes it does appear to be contradictory. So there is an FAQ for businesses, what you do if you have a COVID positive test in your business, and it is fairly helpful. So obviously we first start with the COVID or the close contact rule, but there's also a symptom-based strategy that we should be thinking about. If you've got an asymptomatic person who tested positive, they can return to work within 10 days from the onset of symptoms, so long as they're also fever-free for 24 hours. If asymptomatic can come back 10 days after the positive test without a negative test. And we're going to talk about whether it's appropriate to require a negative test, but the CDC says if you're asymptomatic and it's been 10 days since your positive test, you're likely not shedding the virus or contagious. The same could be true for employees who were symptomatic, so long as 10 days have passed, they're 24 hours fever-free, and they have had improvement in their symptoms. You do not need to require a negative test, though there might be reasons why you would. So there's this tension between the 10-day rule I just talked about for those who are positive and those who were in close contact or have a potential exposure, because there's a 14-day incubation period. Those individuals have to wait out the 14 days of quarantine before they can return to work if they met the close contact definition. Now, to make it even more complicated, if your workers are essential workers as defined by the CDC, and you are able to maintain a 6-foot distance, there's plenty of hand sanitizer and masking, those essential workers, it's possible that they can return to work if they were even contact traced as having that exposure. And those are under the CDC rules for essential workers. While those are broad, you still need to figure out if you are an essential worker and whether you can ask this employee to come to work. There are also special rules for workplaces where you cannot social distance. You can think about a factory line or a situation where the cubicles just aren't far enough apart. There are special rules that are within this FAQ on the CDC's website that can be helpful. We also have scenarios where someone comes back from a vacation and said, I got tested either just before I left or while I was out, and I've been gone for 7 days, but now I'm positive. What are you supposed to do for those coworkers who may have worked with that person before she left on vacation? There are, that creates a lot of different scenarios that have to be addressed. If the positive test was on Friday before they left, then the day of the positive test is who you contact trace. Now, those workers would have had 7 days where they didn't know, and they were probably not isolating, but so they still have another 7 days left on their quarantine. And it's going to create a lot of work for you and human resources. And so if you're lucky enough to have, some assistance that can help you, that is great. And if not, I'm afraid it's just going to end up putting more work on your desk to try to figure out who the right people are to identify as close contact, whether or not they should quarantine, whether they fall into the essential workers category, and what we're going to do about the rest of the workplace. One thing I do want to mention, I said, we can't tell our workplace that, oh, Claire tested positive for COVID-19. But what you can do is get a written authorization from Claire to disclose that. So if Claire says, yeah, it's fine if you tell everyone, get it in an email, or we can provide you with a release that it's okay to just disclose the positive diagnosis, it eliminates any of this worry and fear about, practically speaking, how do we prevent people from talking about Claire's diagnosis or accidentally disclosing it? And we can certainly help you with that. All right, so again, in the event of a positive test, what are we doing in our workplace? What are the issues that we have identified? One, we have employees crying wolf. I've got a cough, I'm gonna stay home. Whether they're using PTO or unpaid leave, that creates excessive absences for you. And how are you gonna deal with the morale issues or the efficiency issues? People sometimes have a desire to stay home. They want to just say, you know what, I've got a cough today, I'm gonna work from home. Well, guess what? You don't have to let them work from home. So you need to have a policy in place with regard to telework if you don't already, especially as this leave is ending. You need to decide whether you're going to offer telework, and if not, people have to take PTO or they have to take unpaid leave. So you don't have to offer telework, even though the governor says, let them work at home if possible. If work at home is not available, it's not available. think about the PR needs, think about, or the PR crisis that could put in place, think about your business needs, but it's something that you should be addressing now. You know, you're gonna get pushback from people saying, well, the governor says we're in a red zone, or the governor says I should be able to work from home, and you can't keep me safe here. Well, we need to address those issues. We need to communicate. We need to show the steps we're taking, make sure the PPE and the sanitizer and the liquid sanitation that we're using, the Clorox wipes are available. Have a cleaning log that's displayed so that everybody can see that the break room was cleaned every 2-3 hours, or the copy room was cleaned every 2 or 3 hours. Not only does this help put your employees' mind at ease, but if the health department walks in, you can show them you are doing everything you can to keep everybody safe. Those discussions about we're not having a safe work environment can really be squelched with communication. Here's what we are doing to keep you safe. Show the plan, communicate. When you have a positive test, make sure you're doing the right things to get information out, protect the people, and again, try to keep while you're trying to keep your workplace going. So then what we have to do now is think about what's going to happen on 12/31 when paid leave runs out and individuals no longer have that paid leave available. You should be developing new policies right now with regard to paid time off, unpaid time, and you need to also respect the needs of your employees while they need to respect the needs of the business. So what are we going to do? Here is our next poll question. Our next poll question is, can an employer require a negative COVID test before a COVID-19 positive employee can return to work? 20 seconds. Yes. Okay. So 72% said yes, 23 no, and 5 maybe. The answer to this is yes, you can require that negative test. We have to think about, though, whether that's practical for our business. We have to worry, there are pros and cons, right? You've got false positives that could keep somebody out longer than necessary. But we also have, on the con side, we have PR within the office. How do we know this person isn't still contagious? How do we know this person isn't still positive? So then we go back to that 10-day rule that the CDC is talking about. And again, we'd have to communicate that with our employees, stop the rumors, stop the speculation, and let them know you are following the guidelines. Let them know what guidelines you're following. And so putting that information out there will hopefully squelch the rumors. And if there are conflicting guidelines, you can say, look, I'm following this one, the CDC, for example, this is what we're doing. And that is, hopefully we'll address some of those issues. So the next issue that we're talking about is moving into the fact that the paid leave is ending. But we still have issues that just because the paid leave ends doesn't mean the issues go away. So we have in our scary story here is you've got employees that are caring for elderly parents that have underlying health conditions that make them at greater risk. And you have people with school-age children. What are we supposed to do when the leave is not available? So again, the Families First Act, as you guys know, has an emergency paid sick leave provision for 80 hours of paid sick leave for one of 6 circumstances, and it provides 12 weeks of family medical leave to care for a child whose school or daycare is closed. Well, those 12 weeks are probably up by now, if not about to run out. Some of your employees might be using it intermittently, but in December 31st, it's over. How are we going to handle it? So the first thing I advise you to do is review your PTO policy. Do you have room there? Can you amend it? Can you add days to help individuals out? Is it something you want to do? Is it something practically you can do? What are your business needs? In the fall, do you generally see a decline in business so that having people out might not affect productivity so well? Or is this your busy time of year where you need people? Those objective criteria can really help in developing these plans. And unfortunately, at times delivering bad news to employees that are going to be either on unpaid leave or who are going to end up perhaps without a job if they're unable to return to work. You've got employees, like I said, who are crying wolf, who are always saying, hey, I've got a cough, I'm not coming in today. If they're not reliable and the leave is running out, we don't have any other paid leave or any new policy, is this an employee that we're going to continue to employ from here on out? Of course, we have to apply this all consistently. Standard employment law rule, I don't really need to elaborate more on that. But I do need to remind you that anyone who has taken this leave, even though the act expires on December 31st, their ability to file a cause of action for retaliation still remains. So we have to remember our retaliation is usually close in time, is the biggest issue, that if the retaliatory act occurs close in time with the exercise of the leave, then it looks like retaliation, even though it might not be. So think about that when you are making employment decisions after December 31st. Does this look like I'm retaliating against them for taking the leave? What type of conversations had my supervisors or have I been having with this person about their need for leave, their taking leave? And is it going to look like a retaliatory act? Some of the common issues we see, obviously, is, here in Jefferson County, we're not sure when JCPS is going to open. Your employees are still going to need time off to care for the school-age children, but they need to also be planning for this. This is not all on you. You can have a conversation, issue a memo saying, look, your leave is about to run out. We still need you here. You need to be planning for the fact that you don't have leave. This is easier said than done. Daycares are having an in-home nanny or a caregiver costs money. Some people don't have friends or family who can care for them, but they need to start planning now. We need to start having those conversations about what we're going to do, because we have to balance our needs and the needs of the employees. So again, we have to communicate. We should be telling them to plan. Everybody should be planning, both you and the employees. What can you afford to do as an employer? Can we afford to have a bunch of unpaid time? And obviously you're not writing a check for unpaid time, but can you afford the lack of productivity? We should be encouraging flu shots. We can't require, but we can encourage the flu shots. And this is one of those that now we're going to have a situation where we're going to have regular fall and winter illnesses that could look like COVID but are not. People are going to be sick. How are we going to balance the flu season with the COVID season? And what does that look like? That these are issues that we need to really be looking at our sick and paid leave policies so that we can get a handle on what's about to come in the coming months. Our next poll question: as an employer, am I required to continue to leave to employees if they have children on a hybrid school schedule after December 31st, 2020? Open for 20 seconds. The answer is no, and your poll questions came out on a majority of you no. We do not have to, but we really do have to consider what our needs are and the needs of our employees. Do we have good employees we want to retain? Is there an opportunity to work from home? Claire is now going to start talking about alternative work arrangements. And this session's probably posed more questions than answers, but because it is an evolution and because every situation is different, we need to just identify those areas where you should be thinking about this possible scenarios and how you can have plans in place to address those, or at least a structure and a framework. And that is the most important thing. And then we can work through these together over the coming months. But with that, we're going to advance and move on to alternative work arrangements, and because they dovetail certainly right into how are we going to meet the needs of the employee absences over the coming months. So I will shut up now and pass it on to Claire.
Hi, y'all. So I am actually working remotely. So if my Wi-Fi goes out or if anything crazy happens, like a child runs into this room, I apologize profusely. I'm quarantined. So poor Cindy had to deal with me this week being quarantined with all of the craziness that comes along. So I'm sure we do understand how difficult this situation is. And so now I'm going to talk about alternative work arrangements while I'm enjoying one. So let's switch to the next slide. So the first scary story is you've had employees working from home for much of the year, and it's actually gone pretty well, as far as you can tell. And you're maybe even thinking about reducing costs by downsizing your office space. So the other day, an employee presented you with her internet bill, which she claims she had to upgrade to be able to work from home, which, by the way, I have empathy for as I worry about my own Wi-Fi. Do you have to pay this bill? Okay, so let's go to the next slide. So before I answer that question, I'm going to talk about some other issues that arise, and then we're going to circle back. When you have alternative work arrangements like telecommuting, there are a lot of problems, identifying employer costs, which we're going to talk about later, but also identifying what's compensable. I'm going to address that now because I have had so many questions about this and managing overtime obligations. So I kind of want to hit that right at the beginning. What I need you guys to understand is anytime an employee is working, it is compensable. And this is particularly important to understand for hourly employees. That stray call, compensable. That email at 9 p.m., compensable. Are you tracking that time? Do you have the systems in place? I mean, this kind of took us all by surprise, this quick work from home. And, a lot of us were behind the gun and didn't have the policies in place. Do you have a way for your employees to report that time? Because if you don't, you need to institute them. If you know about that time, if you find out about that time, like for instance, if your employee turns in their timesheet and you know that she didn't list that 9 o'clock phone call, or he didn't list that 9 o'clock phone call and you were on it, then you have knowledge of that time being worked. And then you can be liable. Now, you can't be liable for time that you had no idea about, but it does present other issues. So if you don't have a system of recording this time, then you're in a he said, she said, and you're responsible for recording these hours and this time worked, and you're responsible for paying them appropriately. So you don't want to be put in a situation where months down the line, some employee says, well, I didn't realize I wasn't supposed to write that down, so I didn't. So that's one issue that you need to address. But then what happens if you didn't authorize that time? So if you didn't authorize the time to work outside their normal working hours, do you have to pay for it? Yes, it is still compensable. You can discipline people from working outside their normal approved hours if you specifically have a policy that prohibits that.
All right, so Claire's Wi-Fi has shut. Oh, no, she's back. All right, so I am going to speak. We'll get Brian to text with her. Sorry for the technical difficulties. Obviously, unapproved time still has to be paid. And so as a result, if you don't approve it, you still have to pay that time. Otherwise, it could be a Department of Labor issue. Let's see, I think, Claire, are you back? Okay, so what other issues could arise with telecommuting? And one of the things that Claire started off talking about were what were the costs associated with this remote work and who has to pay them? So first we talk about an internet access or cell phones. Your employees are probably asking you to pay for these things. And the FLSA and the Kentucky Wage and Hour Act, they don't require the payment of those costs, except to the extent that your employee's wage falls below minimum wage. I see Claire is back. And so okay. I will go ahead. We started talking about the costs associated with remote work and that it has to at least keep you at minimum wage, but I'll let you go ahead since this is your session.
Okay, thanks. Sorry, guys. I mean, it's so hard. Okay, so before we go back, let's go to the next question before we talk about that. If you could advance the slide. Do employers have to pay expenses associated with the employee's home office, such as reimbursement for data usage, use of cell phone, personal computer, and internet access? So I assume a poll will pop up. Yes, no, or maybe. Yes, here's our poll. Okay. And by the way, this also includes what about upgraded internet, like we discussed before? Okay. Okay, So 49% of you said no, and you guys are right. The answer is no. Okay, employees aren't entitled to the very best internet in the world. However, if it does, keep them from doing the essential duties of the job, like possibly right now, you might want to upgrade that internet. Hopefully we won't have any more problems. Maybe with 3 kids and a spouse and, everybody streaming content, it might become something that is necessary, but you still don't have to pay for it necessarily. You don't have to reimburse your employees for expenses related to working from home unless the expenses reduce the employee's earnings below the required minimum wage, or, and this is a big or, telework is provided as to a qualified individual with a disability as a reasonable accommodation. And then that's something that you do have to reimburse. Okay, sorry, I'm trying to get settled in a new room. Okay. So next slide, expenses associated with remote work, who pays? Okay, so again, this just basically gives you the guidelines. You don't have to pay except for those 2 instances, but that said, you may still want to because, there are a lot of expenses, paper, printer, ink, internet that actually works. And so you want to establish goodwill with your employees, and this will do it. You also want to control information. We're going to talk a little bit more about that later, computers, cell phones, and you want to control costs. You get to take advantage of economies of scale. Most likely your employees, they don't get that benefit. So the cost will actually be higher if they run out to Office Max and go get printer paper. Okay, so let's switch slides. Okay, so employees are increasingly using their own devices to conduct company business, even if they're working from home. So what are some of the negatives about this? And, you have some risks listed in this slide. Well, the most glaring negative, in my opinion, actually, is that whenever an employee brings their own device to work, IT departments lose a lot of their control over the hardware. They can't control what apps or programs are installed, how the devices are secured, or what files are downloaded. Staff may also resent paying for their own phones, laptops, or tablets. Sensitive data could be lost when an employee leaves. While there's plenty of software that can wipe a phone remotely, employees are loath to install it. I know I never have. And even if they do agree to install it, IT departments may not want to be responsible for wiping out everybody's photos from Christmas morning when they leave. And so there are a lot of issues to think about. So let's go to the next slide. What we recommend and what we will draft and most employment attorneys will recommend is you need a good bring your own device policy. And what does this policy look like? Mobile device management technology, separating work data from personal data. This is a big issue. Outline it. Describe what that looks like. What types of devices will be permitted and what company data will be accessed remotely? Do you have a preferred provider? Do you only allow BlackBerrys back in the day? Or are you okay with an iPhone or whatever phone that they have? Who will be permitted to use their own devices and why? Is this just for upper management or is everybody allowed? When off the clock work occurs, specifically for hourly employees, is there a way to track that on their phone? Is there an easy way to track that on their phone? And you want to establish clear rules that outline employees' rights and limitations to access, monitor, and delete the data. So we want to, as an employer, you want to preserve that right to delete and access that data. All passwords need to go through you. You also want to have clear rules relating to what they can put on their phone. Can they download anything? Can they include any app? Can they include any software? Those are the things that you have to have in your policy. So next slide. Okay, so now we're going to talk about some discipline issues with remote employees. So you've had an employee working from home for much of the year and they want to continue. But while some have thrived, others have not quite met your expectations. How do you handle it? Next slide. Okay, so of course, again, as the lawyer, draft a policy. That's our answer for everything. But it actually is a good answer. You need to clearly define your expectations. And I think, we all wish that we had a policy in place prior to being told to send everybody home. Really would have been nice. But that just wasn't the way that work was done before COVID. But now we do have to have a policy because we don't know when this is going to end. You want to clearly define expectations and state that remote work options can be revoked at any time. There's no guarantee. You want to reiterate that you intend to discipline folks in the same vein as you disciplined at work. There are responsibilities. And what you want to do, your end goal, is you want to allow employees to understand their expectations. And so these policies really, really help. One of the things that I think our firm did that was wonderful, and I appreciated so much, was we established a communication funnel. So we would check in every single day with our teams, and we had different teams, based on the work that you did, which for me was wonderful because it enabled me to meet people that I hadn't worked with before, and cross office lines from in our office, Louisville to Lexington. So that made me feel really connected when we were first forced to stay at home, to work full time at home. And I think that those programs, allowing your employees to understand the expectations and creating funnels of communication, really, really do help the work get done. So next slide. Oh, we have another question. So an employee requests remote work as an ADA accommodation. The employer was previously denied such accommodation because it was not feasible to perform the essential functions remotely. In the past few months, remote work became the norm. Must the employer now make the accommodation? Oh, yes, no, maybe. Those are your options. Okay. Oh, so it's pretty split, which is actually interesting and correct that it is completely split because the answer is maybe. It's kind of a hard one. Okay, so let me back us up. The first thing you want to do is you want to say, is there a disability related limitation that requires telework? Okay, and I want to repeat that requires telework. If there is not a disability related accommodation that requires telework, then the employer does not have to provide telework as an accommodation, unless if there's a disability related accommodation and, well, let me restate that. The other thing is, or if there's a disability related accommodation limitation, but the employer can effectively address that need with another form of accommodation, then they can choose that. So even if work from home would be an appropriate accommodation, but the employer doesn't want to use that accommodation and there's another one available, they can avail themselves to that. So it's not an end all be all, but here's the kicker. If the previous request was denied simply because it didn't seem feasible, like for instance, you said, we don't have the computer, we don't have the setup, we don't have a printer, and now all of those things are satisfied, you can't just say no to the renewed request. You have to engage in the interactive process. So that is a responsibility that you can't just eschew that responsibility. You have to revisit it if the accommodation request was denied based on something that's now been remedied. But, okay, but I will say there's other issues to consider. Many folks were taken by surprise with this. And so these, when the stay home orders came down, a lot of employers sent employers home and removed some essential functions of their jobs to allow them to perform like a skeleton version of their job. If an employer did that, they're not obligated to continue removing those essential functions. So you can deny an accommodation that was based on a removal of certain essential functions. Okay, so next slide. Okay, so reasonable accommodation. What you're going to say is, let me see. Oh, am I behind? Yeah. Is the condition a disability? If not, there's, okay, now I know what I'm doing. Sorry about that. Okay, so COVID-19 places renewed focus on reasonable accommodation, and we're talking about different types of reasonable accommodations. A lot of people are requesting for a reasonable accommodation because they're in a vulnerable population. And so that might mean 65 or older. I doubt it means somebody living in a nursing home, but anyone with an underlying medical accommodation or medical condition. So do we have to grant an accommodation for that? And so again, we go back to the original question. Is it a disability? If there's no requirement that that it's a disability, if it's not a disability, there's no requirement that they provide an accommodation, but you may choose to do so. Like you could make that choice. But a lot of folks are saying, but wait, I don't have a disability. I don't have an underlying medical condition that rises to the level of a disability, but I'm over 65, a statistically vulnerable group. Can I have an accommodation? Or let me put it another way. Should I tell all of my employees who are 65 or older that they can stay home and then recall the rest? And that's actually a question that we've had. And the answer to that question is no. The Age Discrimination in Employment Act prohibits employment discrimination against individuals 40 or over. And that's true even when you're doing it for a benevolent reason like protection. And unlike the ADA, there's no right to an accommodation based on age. However, again, the employer can make a choice to be flexible with people who request an accommodation 65 or older. And that's true even if it disadvantages people who are 40 to 65 or results in younger workers aged 40 to 64 being treated less favorably. So you can make an accommodation. You can't make the decision for them necessarily. So here's another question that I have had. Is an employee entitled to an accommodation under the ADA in order to avoid exposing a family member who is at higher risk? So your employee doesn't have a disability, your employee isn't over 65, but they have somebody at home that they're living with that they're concerned about. Are you required to give that accommodation? And the answer is no. Okay. So the next thing we're going to talk about is politics. And let me make sure I'm not too late. Okay. Politics and social issues at the workplace. So our first scary story is during the pandemic, you let the dress code get a little bit more lax. And one employee wore a t-shirt supporting a particular social issue. The next day, a coworker chose to wear a t-shirt of a political candidate deemed to be in opposition. These two start going at it. There's Facebook postings, everything goes haywire. Is there something that you can do as an employer to ease these tensions? So I will say everybody has opinions, sometimes strong and emotional opinions about this election. Social unrest has pulled many issues to the forefront related to gender and race in America. And let's not forget the politicization of COVID-19 restrictions, which are always super fun. So it feels like there is a lot to disagree about, and these disagreements feel more personal than usual. So a lot of tempers are flaring. So the question that we have is, an employer wears a t-shirt to work with a social cause. It offends someone. The dress code allows t-shirts and does not exclude shirts with graphic or words on them. Can the employer take disciplinary action against the t-shirt wearer? So let's see what you guys say. Okay, so no. Most of you guys said no, and that is in fact the correct answer. Although I would argue that there are other extenuating circumstances. But what you need to know is if it doesn't violate any policy, so for instance, in this case, the dress code, then there's no reason to discipline. However, if it does violate a policy, which it might, related to respectful, so if it's obscene, for instance, or if there are other issues that you need to look at, then you might be able to discipline, but it's based on your policies. see. Now, what I would say, and I've said this now 3 times, so I feel kind of like a broken record, is what is the best way to handle this? A policy. So you want to dust off your respectful behavior policies, your code of conduct policies. Do these need to be supplemented? If you don't have a dress code, or if you don't have a code of conduct that addresses dress and t-shirts and hats and pins, or even if it doesn't address the failure to respect divergent views, opinions, and beliefs, now is the time to put one in place. And I think a lot of people are hesitant to do that because they feel like it's a third rail. They don't want to get involved in their employees' belief system or perceptions. But what we can say and what we should say is that you are responsible for being respectful in your workplace. And you are responsible for treating your coworkers with respect. And in that policy, you want to describe the types of conduct that's prohibited by these, attacking people's belief is prohibited, political or otherwise, and explain how violations occur. Describe what those violations look like, and reiterate that if this disrespect rises to the level of harassment, it could lead to discipline up to and including termination. But if that doesn't do the trick, let's go to the next slide. If conversations are getting heated and disruptions are occurring, you can actually prohibit political dress, pins, hats at the workplace. So unless you are a government employer, so all public, private, and nonprofit employers, you can prohibit those types of messages. And you can do it in the same vein as you would any other potentially disruptive content. So everybody says, and I've heard this so many times from employees, but I have free speech rights. Okay, but again, no, you don't. If your employer, unless your employer is a governmental entity, your employees have no free speech rights at work. So as such, in private, public, and nonprofit employers can regulate free speech as they would any other disruptive speech. Now, there's a caveat. What employers cannot do is regulate speech that affects wages, hours, and working conditions. So this is a weird quirk. So if there's a shared discussion or an argument about maybe a new bill or a political movement that raises the minimum wage or changes overtime rules, think before you step, because unless that conversation is disruptive, it may be protected. Just a word to the wise. And by the way, calling one of the presidential candidates a bum or a hero is not going to be protected speech, so you don't have to worry about that. Okay, so next slide. While it is legal for you to prohibit political speech at work, it might be preferable to use these times as a teaching moment. Restrictive workplace rules can lead to discontent among your employees and only exacerbate the problem. I recommend instead that you teach your supervisors how to handle these times. You want it to foster respect via office policies and training without mentioning politics, and set clear guidelines about what happens and how you deal with when an opinion arises to the level of harassment. Lead from the top. Your managers should be your best role models. They should keep their political opinions to themselves to avoid alienating workers, but also take pains to stop that influence from coming into the workplace. Turn off televisions, turn off radios, don't have any open displays of political posters, campaign buttons, and steer conversations away from such topics. So, next slide. I would say that all of this is coming pretty quickly, but we don't know when it's going to end. We don't know when this election will be called. So I would recommend that even though the election is only days away, you guys address this now because it could get really, really heated in the days to come. Set at your expectations and let employees know that any altercations or disruptions will result in each employee being involved, disciplined, or sent home, or whatever you choose. You want to institute a no fault policy right now so you can control any conflict that occurs and explain this policy is so we each learn and practice respect towards each other and each other's opinions and views. And I think that's all I have for you. And we're almost done.
All right. We have 2 questions. As you can see here, Brian in our marketing department is a fan of the graphics and had a lot of fun with the graphics in preparing this seminar. So we hope you appreciate it as well. The 2 questions we've had: if an employee has tested positive but has not been in the office, do you still have to contact the health department? If they've not been in the office, I would say no. The employee's positive test will be reported by their physician or whoever took the test, and you would not have to report it. The next question: can you prohibit political messages from board members? In other words, Facebook posts, hats, shirts, etc. And again, the answer to that, unless you're a public employer, unless you are, a governmental agency, the answer to that would be yes, you can. Board members have far fewer rights than employees. To the extent Claire was talking about, messages or political messages about terms and conditions of employment when she was talking about a wage and hour type of issue, a board member who's not an employee doesn't have that protection, and you can, subject to your bylaws, you can create social media policies with respect to board members that are very different from your employees. And in fact, we have done those in the past. So we are right at noon. I don't see any other questions. Oh, we do have one more. Oh, there's a chat. Hold on. I'll make sure we get to this. There it is. Don't see it. Can you read it to me? Okay. Brian's going to read me the chat and I'll read it aloud to you as well. Can an employee refuse to use their personal cell phone or computer for work-related reasons? The answer to that is no. We talked about the fact that you should be providing your own devices for various reasons, and that there are reasons why you would pay for those devices. But the condition of you having a cell phone to be available is absolutely appropriate to be used, to be required of those employees. The one caveat would be if their provision of that cell phone policy, even if it's unlimited, would take their wages below minimum wage, I think, and the use of the cell phone or the computer is for your convenience, then I do believe that you would have an issue. So subject to that minimum wage issue, I don't think we would, I think you can require them to bring their own personal devices. Claire, do you have anything to add to those questions?
No, the only other exception I would have is if it's a reasonable accommodation for a disability, then you might have to front that cost.
That's absolutely true. I appreciate that as well. Again, we thank you guys for joining us each and every year. It's a lot of fun to do this on Halloween and to wrap up the year. We try to bring in normally the situations we've experienced over the year, and they're usually a wide variety of issues, but this year, as we know, it's all been related to this pandemic and the situations that have arisen. We wish you the best of luck in completing this year. And as always, if you have any questions, feel free to reach out to Claire or me or anyone on the employment team. We will send the slides out to everyone who registered so that if there's information on there that you missed along the way, you'll have those in your inbox. Thank you so much and happy Halloween.